Imagine being the lawyer who walks into Mar-a-Lago and has to say these exact words to Donald Trump. "Sir, we have a catastrophic problem. The document we thought was destroyed in 2020. It wasn't, and it's now in Jack Smith's hands." That conversation happened 72 hours ago, and what makes it absolutely devastating is not just that the document exists. It's what's written on page 4. A handwritten note. In Trump's own writing, with a date that directly contradicts his sworn deposition from 8 months ago. Right now, that document is sitting in a secure facility in Washington, D.C., and federal prosecutors have already scheduled depositions for 6 witnesses who can authenticate the handwriting. If you find this breakdown useful, hit like and subscribe. It costs nothing, but it helps more than you think. And this story is moving fast. This is the story of the one piece of paper Trump's legal team thought had vanished forever, and why its sudden appearance could be the final blow his defense can't survive. To understand this story, we have to go back to the story of how the document was lost. Because how it was lost matters far more than how it was found. November 2020. Election results are becoming clear, and everyone in the White House knows one thing. A transition is coming. And during transitions, there's one thing that must be done. Organize the documents, determine what needs to go to the National Archives, separate what's personal. But for some documents, that decision is far more complicated, because some documents have a dual nature, official on one hand, personal on the other, and some documents don't fit into any category because they should never have existed. This document was in that category. According to records, the White House legal team created an inventory in December 2020. Sensitive materials, high classification level notes, and most importantly, anything written or signed personally by Trump. Inside that inventory was a note. Memo, Dec 18 Classification Review. Destroy per POTUS instruction. Destroy per presidential order. This type of directive is not unusual. Presidents routinely request the destruction of draft notes, personal thoughts, or sensitive strategic materials. It's a legal process. But there's a problem here. The document was not destroyed. And now the question is, why wasn't it destroyed? Because the person tasked with destroying it noticed something. There was a different date on the document, and that date didn't match Trump's later statements. That person didn't destroy the document. They hid it and stayed silent for 2 years. So what exactly was this document? According to publicly available information and Federal Archive records, the document consists of 4 pages. The first 3 pages are printed text. Official looking. Title. Classification Review Protocol. Presidential Records. This part is technical. Dry, full of legal jargon. Standard procedure explaining which documents should be maintained at which classification levels. But the 4th page is different. The 4th page is a handwritten note. 2 paragraphs, 11 lines, and at the bottom, a signature. The content of the note is about a phone call. Date, December 18th, 2020. Call time, 14:37. Person called, name abbreviated, listed only as MP. Subject, declassification timeline. Need final approval before transition. Declassification timeline. Need final approval before transition. Now stop. Let that sink in. December 18th, 2020. This date is critical. Because in his sworn deposition in May 2023, Trump said something clear. I had no active discussions regarding declassification processes in late 2020. The only thing I was focused on was resolving the election results. But this note says the opposite. It doesn't just say a discussion happened. It gives a date. It gives a time. and it gives one more detail. Need final approval. Need final approval. This phrase implies something. There's a chain of decision-making, and Trump is at the end of that chain. And this is where things become truly dangerous, because this isn't just a contradiction. This is potential perjury. Under federal law, making false statements in a sworn deposition is a crime. 18 U.S.C. paragraph 1621 perjury, penalty up to 5 years in prison. But here's the key. The false statement must be willful. Forgetting isn't a crime. Misremembering isn't a crime. But consciously stating something contrary to the truth, that's a crime. And this is why this document is so dangerous. Because the document doesn't just show that Trump had a phone call. The document shows the details of that call. In handwriting, in his own notes. And these notes make the "I might have forgotten" defense impossible. Federal prosecutors who obtained the document initiated a 3-phase verification process. Phase 1. Handwriting analysis. The FBI's documentary department compared the handwriting on the document with other known examples of Trump's handwriting. Letters, signatures, private notes. Result: high probability match. Phase 2. Metadata examination. The date the document was printed, printer information, file creation time. Digital footprints. And these traces show the document was printed from a printer in the West Wing of the White House in December 2020. Phase 3. Witness depositions. Federal prosecutors identified 6 people who were aware of the document's existence or who worked with Trump during those dates. And right now, a deposition schedule is being created for these 6 people. Deposition, sworn testimony. This is no different from testimony under oath. You may not be in a courtroom, but you're under oath. And every word is being recorded. If one of these 6 people talks, they won't just authenticate the document. They'll provide the context of that day, who was there, what was discussed, and most importantly, whether Trump knew he was keeping that document. Now let's get to the political dimension of this story. Because this isn't just a legal matter. This is a bomb exploding in the middle of the 2024 election. Trump is currently a defendant in multiple cases. Classified documents case, January 6th case, Georgia election interference case, hush money case. 4 separate cases, 4 separate jurisdictions, 4 separate jury pools. And in each case, Trump's defense strategy is based on the same foundation. This is a witch hunt. This is a political attack. I committed no crime. This narrative is working. The base is solid. Donation amounts are breaking records. Polls are strong. Trump is using the victim narrative magnificently. But this document threatens that narrative. Because this document isn't an allegation from outside. This is Trump's own handwriting, his own notes, his own signature. You can't say fake news. You can't say fabricated evidence. You can't say enemy media. These are words from your own pen, and this is why Trump's legal team is in a panic. Because this document doesn't just affect one case. It affects the entire defense strategy. The same argument is being used in all 4 cases. There was no intent. There was no malice. There are only misunderstandings and misinterpretations. But this document shows intent. It shows planning. It shows conscious decision-making. Rehook 4/1730. And inside the Republican Party, this is quietly creating a breaking point. Trump's allies in Congress have framed every case so far as a political attack. They supported every hearing. They rejected every allegation. But in backroom conversations, there's a different tone. Several senior Republican senators told reporters anonymously, if this document is real and the handwriting is verified, it becomes much harder to defend. These statements aren't public, but they're on record, and these statements signal something. Cracks are beginning to form within the party, because as 2024 approaches, Republican strategists are making a calculation. How sustainable is continuing with Trump? What happens when juries start deciding? What happens when convictions come? And this document changes that calculation. So what will Trump do? Based on past behavior, the likely strategy is deny, attack, delay, deny. I didn't write this document. The handwriting isn't mine. This is a fake document. This is disinformation. This argument is difficult because the FBI will present handwriting analysis results to the court, and while the opposing side may bring their own experts, the burden of proof will be on Trump. 2. Attack. Who leaked this document? This is betrayal. This is illegal information sharing. How does a prosecutor have a document and nobody knew about it? This argument is politically strong, but legally weak, because how the document was obtained doesn't change the validity of its content. 3. Delay. We object to the admissibility of this document. We question the integrity of this document. We request this case be postponed until after the election. This strategy is Trump's strongest weapon, because the legal system is slow, and every objection extends the process by a few more weeks. But here's the problem. This time, he's facing a different prosecutor. Jack Smith, special counsel, and Smith is taking an aggressive stance against delay tactics. He's responding quickly to every objection. He's trying to get every postponement request denied, and so far, judges are siding with Smith. Because judges are aware of one thing. If this case is postponed until after the election, what happens if Trump wins? And this is where the most complex scenario in American legal history comes into play. What happens if Trump wins the election in November 2024? And what happens if he's still a defendant in federal cases when he wins? The legal debate is, can a sitting president be prosecuted? The answer is ambiguous, because this has never happened. Nixon was pardoned. Clinton faced impeachment while in office but didn't face criminal prosecution. During Trump's first term, the Mueller report came but no charges. But now it's different. Now Trump is a defendant in 4 cases, and these cases are moving rapidly. If conviction comes before November 2024, Trump becomes a convicted presidential candidate. And in that case, what does the Constitution say? Nothing. Because the founders never imagined this. What happens if conviction comes after November 2024 but before inauguration? Does Trump go to prison as someone who's been elected president but hasn't yet taken office? And the most complex scenario. What happens if conviction comes after Trump becomes president? Can he pardon himself? These questions aren't theoretical, they're real, and their answers will be determined in the coming months. This document's story goes far beyond an ordinary legal matter. This is the story of how a man can become the victim of his own notes. This is the story of how nothing truly disappears in the digital age. This is the story of how power can be shaken by a single piece of paper. For years, Trump said, witch hunt. He said, fake news. He said, political attack. But this document says nothing. It just presents a truth, a date, a note, a signature. And sometimes the most dangerous evidence is the quietest. Now federal prosecutors are examining that document. Witnesses are testifying, courts are setting dates, and Trump's legal team is trying to answer this question. How do we explain that document? Because this time, saying fake news won't work. This time, the evidence comes from his own camp. Thank you for watching. If this analysis helped you understand what's happening, hit like and subscribe. It's free. and helps more than you think. Check out the next video on screen, and I'll see you in the next one.